So this morning I'm going to talk to you just generally about some updates in trademark law in the past year. For some of you who have been paying attention to some of the trademark cases over the past couple years, I will be giving a little background on some of the cases because they started obviously, as most cases do, in the past, and they came up as issues that sort of have culminated this year, or we'll be looking at things that will culminate next year. The first and perhaps one of the more significant, certainly Supreme Court decision cases out there on trademarks is the Mattel v. Tam case, previously called Lee v. Tam, but now it is the Mattel v. Tam case. And this case has to do with Section 1052A of the Lanham Act. And I put up the statute here, and it references Section 2A of the Lanham Act requires that basically all trademarks be registered unless they don't comply with certain provisions of the Act. And so under 52A, there are limitations in registration, and it provides that no trademark shall be refused registration on account of its nature unless, and then a few other things listed, but it consists of or comprises of immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. So the Mattel v. Tam case deals with the language that I have underlined here, which is the disparagement, which is known as the disparagement clause of 1052A. So since the enactment of the federal trademark statute, the Lanham Act has banned banned registration of marks that would be disparaging to any group or individual. The PTO previously has used Section 2A to deny or cancel disparaging marks such as Stop the Islamization of America, the Christian prostitute, Democrats shouldn't breed, Republicans shouldn't breed, and things of that nature. Perhaps most notably of recent date, the Trademark Office and the TTAB refused or canceled registrations with respect to the Redskins marks owned by the NFL Washington Redskins team. So correspondingly, there has been this case that's sort of been going up that had a petition for cert on the Redskins case. The Supreme Court decided instead to take the Tam case, and as background to that, in 2011, Simon Tam, the lead singer of a dance rock band with members of Asian descent, sought to register the trademark The Slants as the name of the band. The trademark examining attorney at the USPTO refused registration of that mark on the basis that the mark may be disparaging to Asian Americans. The PTO relied on dictionary definitions, relied on newspaper articles, and information from various groups of Asian Americans saying that the term The Slants is disparaging. Trademark Trial and Appeal Board affirmed the refusal of registration, and Simon Tam appealed this to the Federal Circuit, arguing that essentially the denial violates the First Amendment right of free speech. The court, the Federal Circuit, in an en-banc decision said that disparagement clause is facially unconstitutional under the First Amendment, violates the free speech as impermissible viewpoint discrimination. Created a circuit split. Fourth Circuit had previously upheld the same type of language, upheld this provision in a different case in the past. So so the PTO, the government, appealed to the Supreme Court. And the Supreme Court, like I said, had the potential of taking this case or the potential of taking the Redskins case, and took this case on instead of the Redskins case. There's some chatter out there that one of the reasons to take this case instead of the Redskins case is because in this situation, what you had was an individual of the group that the derogatory language was being used, someone from that group. So you have an Asian American saying, hey, I want to use the slants, as opposed to the Redskins, which is a football team, obviously, and it was members of some of the tribes, the Native Americans, who were raising an issue with that. At any rate, that is what the Supreme Court decided to do. And so the Supreme Court took this on, and this past June, they struck down the disparagement clause of 1052, agreeing with the Federal Circuit that, this is just the slants group up there, agreeing with the Federal Circuit that the statute amounts to impermissible viewpoint restrictions. Basically, it permits registrability of positive references, but denies registrability when it is deemed to be a negative reference. The government had made various claims and assertions as to why this should be upheld. First, they argued that because trademarks serve a commercial purpose by identifying source of goods and services, their commercial speech, and then, of course, entitled to less protection under the First Amendment. They also argued that Section 2A of the Lanham Act simply sets a standard for conferring a government benefit, and that the government has the right to make restrictions on any benefits that they grant. And third, they argued that because the trademarks are actually approved by the government, by a government agency, that trademark registration is a form of government speech. Justices Alito and Kennedy, who wrote two of the opinions for the members, each for 4 members of the panel, emphasized essentially, outright rejected these. Well, Alito outright rejected all 3 arguments. Justice Kennedy focused really on the issue of viewpoint discrimination. But with respect to both, essentially they said you can't just allow registration of happy talk or mandated positivity, that it is a viewpoint bias, discrimination, and therefore struck that down. So the question becomes, what's the effect of this? How does this play out? So essentially, we have the holding disparagement clause of 15 U.S.C. 1052A is facially invalid under the free speech clause of the First Amendment. So what is the effect? One thing is clear, the disparagement clause itself is dead. So, weeks after the decision came down, the government, the Justice Department sent a letter to the Fourth Circuit that had some issues going back and forth on the case there, essentially indicating that the circuit had required the parties to send in some type of correspondence to address the impact of TAM on their case. And the Justice Department said, the United States concurs with the appellant pro football that oral argument is unnecessary. The Supreme Court's decision in Mattel v. TAM controls disposition of the case. And consistent with TAM, the court should reverse judgment of the district court, remand the case with instructions to enter judgment in favor of pro football. And so that we are clear about. Everyone is in agreement that this part of the provision is dead. What else does it mean? One of the concerns was that there is going to be, when this case came down, and actually prior to the decision coming down, there was a lot of talk about the fact that what's going to happen is now we're going to have just this plethora of offensive marks being filed, of disparaging marks being filed at the USPTO, and it was going to just take over, and this was going to just be somewhat of a disaster. What we found is that isn't necessarily the case. What we know so far is that there's a gentleman who, the very day the case came down, turned around and filed 3 different trademarks, 2 with variants of the N-word and 1 with a swastika, and for various clothing articles, retail services. So these were filed, 2 were filed on June 19th, the day the decision came down, and 1 was filed a week later. Those made big news. The gentleman said, essentially, my intent is to prevent racist groups from making money from these words, so I'm going to try to obtain registration of these marks and therefore offset the ability for them to do that. How that will play out, we don't know. Number one, he filed these as intent to use applications unless he actually makes use of these marks somehow on the goods and services that he has applied for. He won't be able to perfect these registrations and they'll ultimately go abandoned. So whether that will have any impact or not, we don't know. Number two, of course, he's only applied for the marks in connection with specific goods and services, which leaves the rest of the collection of goods and services that are out there that someone could register in as well. So I don't think it was particularly an effective route to take. He has filed them. They are still new applications. There hasn't been, he has not perfected them. He has not filed statements of use. And my guess is that'd be hard to do if this is his true goal. Other than that, you aren't seeing a lot out there. No one's talking about it. I tried to do some research myself, putting in what I think of as some offensive words or disparaging words, and I have not seen anything that's been registered. My expectation is we'd see a lot out there, in blogs and whatnot, if that were happening. So I think that is probably not what's going to happen from this, at least for the time being. Another question becomes, what is the effect on the scandalousness provision, if that's a word, but the scandalousness provision, we'll go with that. Again, 1052A, same part of the Lanham Act, provides as well that no trademark shall be refused registration unless it consists or comprises of immoral, deceptive, or scandalous matter. Ignore the deceptive for a moment and just look at the immoral and scandalous. Those are what people consider to be the scandalousness provision. And the question becomes, at this point, does the Supreme Court's decision impact this? That issue actually is currently before the Federal Circuit. So before the Supreme Court decision came down, there was a trademark application for the word F-U-C-T filed by a gentleman named Brunetti. The Trademark Office rejected that application, finding that it was vulgar, profane, and scandalous slang. The applicant, who had a clothing brand under this name, appealed to the Federal Circuit. The case was on appeal when the TAM decision came down. The Federal Circuit asked for subsequent briefing from each of the parties with respect to the impact of TAM on this. The government's position is that, so this is the issue that is before the Federal Circuit, whether the TTAB erred in affirming the examiner's refusal to register the mark FUCT under Section 2A, because according to the attorney, the term FUCT is the phonetic equivalent of a slang word or a swear word, the past tense. Okay. So the government's position is that the disparagement clause and the scandalousness or scandalous and immoral clauses do not rise and fall together, that we have a different issue here. Essentially, they take the position that even if the disparagement clause is considered viewpoint discrimination, as the Supreme Court has found, the scandalous clause is viewpoint neutral. The government differentiates between content-based discrimination, which occurs when the government attempts to censor all speech, and viewpoint discrimination, where the government, a subset of that, where the government reviews the speech based on trying to censor certain opinions or viewpoints about a topic. And so the government's position is these do not rise and fall together. Of course, the position of Brunetti is that they do. rise and fall together. And right now, this case, so the case was heard August 29th, 2017. So we do not know how the Federal Circuit will rule on this. What we do know is that it is likely to go up on appeal. So if the Federal Circuit strikes down this clause as well, that'll be a different ruling. It'll again create a circuit split. That'll be a basis for appealing, but it's likely that we might see an appeal on this either way. And the government's focus actually was the fact that, as I said before, Justices Alito and Kennedy took different positions, and Justice Kennedy took a very narrow position and only addressed this on the viewpoint discrimination side of this, and not the other issues argued by the government in that case. And so they're saying, look, Justice Kennedy is speaking for half of the court, essentially, because he wrote for 4 justices, is letting us know that he doesn't think that this is where this should go. These are different areas, and we should be looking at this differently. So for now, the USPTO, in its procedures, they are suspending any action on marks subject to refusal under the scandalousness provision until in re Brunetti is decided. So they have, if anyone's filing anything, those are just being suspended until that decision is set forth. Other possible effects from this case. So one other issue that's sort of been talked about is whether the TAM decision will have any impact on dilution under the dilution by tarnishment claims under the Lanham Act, 15 U.S.C. Section 1125C, also known as Section 43C. The dilution by tarnishment tort allows an owner of a famous mark to challenge use and registration of a mark in a context that reflects poorly on the plaintiff's mark. For the sort of well-known case with respect to this is the Victoria's Secret Catalog v. Mosley case, where the Sixth Circuit affirmed back in 2010 a finding that of likely dilution after Victoria's Secret's successfully demonstrated that the defendant had used Victor's little secret with respect to a sex toy store. And the Sixth Circuit said that that was dilution by tarnishment and enjoined Victor's little secret from being used. There are no cases that I've been able to find as of yet with respect to whether anyone's even, in responding to any complaints for dilution by tarnishment since June 29th. There is a lot of talk out there that this will be something that defendants will be able to use as a defense to a dilution by tarnishment case in the future, because essentially, again, you're just talking this viewpoint discrimination. So it's either, that separation between benign or positive commentary and derogatory commentary. So this is certainly not anything that's set in stone. It's just discussion that's out there, but it is something to consider, certainly if you have a dilution by tarnishment case brought against a client. So that is Mattel v. TAM and sort of the effects that I have seen with respect to that as of yet. The next case that I want to talk about is a case that actually there was cert denied on this year as well from the Supreme Court. And in this case, you have Bayer, a company that is familiar to many, the owner of the Aleve product in the U.S., has for many, many years utilized the term Aleve in the United States, but outside the United States, they've used another term for essentially the exact same product. And what they used in Mexico and other Hispanic countries is the mark Flanax. And they have that mark registered outside the U.S., not registered inside the U.S. So somewhere around 2005, a company named Belmora registered the mark Flanex in the United States and began a targeted marketing campaign to Mexican Americans for their pain reliever called Flanex. Bayer petitioned for cancellation based on deceptive use of this mark in 2007. For some reason, obviously they weren't aware of it at the time of the when they could have filed an opposition, so the mark was registered, but they filed a motion to cancel, they filed a petition to cancel that, and the TTAB and the TTAB granted that petition to cancel. Belmora appealed to the United States District Court for the Eastern District of Virginia. The District Court dismissed Bayer's claims and reversed the TTAB decision, based on the fact that Bayer did not have a protectable interest in the United States for Flanex, because they didn't use this mark in the United States, because they didn't register this mark in the United States, so they had no protectable interest here. They would have no economic loss of sales here, and so it was outside the Lanham Act's zone of interests. Bayer appealed the decision to the United States Court of Appeals for the Fourth Circuit, and the Fourth Circuit reversed, concluding that the Lanham Act's plain language contains no requirement that Bayer have used a U.S. trademark in U.S. commerce to bring a Lanham Act claim. And so court said, if you want to bring an unfair competition claim under 1125A, there's no requirement in there that you actually have used a mark in the United States. Court based the ruling on the Lexmark international case from the Supreme Court back in 2014, which held that preventing unfair U.S. competition by deceptive and misleading use of foreign trademarks is within the zone of interest protected by the Lanham Act, and that Bayer has pled sufficiently proximate cause of injury by Belmora's deceptive advertising. Belmora filed petition for cert, but last fall the petition was denied on February 27, 2017. The takeaway from this is essentially that you can be a foreign company, you can be a U.S. company, doesn't matter. You can have if your interests are harmed here in the United States, and you can make a claim for that, whether or not you use a trademark here or have a registration here, you do have the ability to bring your claim here. From my perspective, one of the things that would certainly be an interest for Bayer in this context is it is a similar product to the Aleve product, and if Belmora is targeting Mexican Americans for a competing product to Aleve using a name that Bayer owns in another country, so making that connection that they could be losing sales of Aleve to people buying the Flanex from the competitor. So certainly it is a possibility to bring those claims today. This is just the issue was whether sections 14.3 and 43A allow foreign businesses that neither used nor registered the mark in the U.S. To sue for unfair competition here. So the next case that I want to talk about is the International Information Systems case, which is a case that relates to the doctrine of nominative fair use. This is a doctrine which has existed now for many years back, but started in the Ninth Circuit with the New Kids on the Block case. And this doctrine essentially excuses use of another's trademark to describe the entity's goods or services. Actually, I have that here, dated back to 1992. So in 1992, in the New Kids block, there was a newspaper conducted a poll that sought to determine the hottest member of the New Kids on the Block band, and the New Kids on the Block sued for trademark infringement. Judge Kosinski, who authored the opinion in that case, developed a three-part test to determine if that use would be excusable fair use, and held essentially that as long as you need the mark to refer to the plaintiff, you use no more than is necessary of the mark. For example, if you use a word mark and not the logo, and you do nothing to suggest the mark holder's sponsorship or endorsement, you're not liable for trademark infringement. Under the New Kids test, when nominative fair use is raised in response to an infringement or an infringement claim, the plaintiff has the burden to show that the defendant's use does not constitute nominative fair use before you even get to the issue of likelihood of confusion. So typically in a trademark case, you have the burden is on the plaintiff to prove likelihood of confusion, and defenses come sort of after that. And in the Ninth Circuit's review of this doctrine, the nominative fair use, they have held that that's the first issue. It's preliminary. We figure out if it's nominative fair use, and it only if we determine it is not nominative fair use do we go to the issue of the general issue of likelihood of confusion. Since 1992, several circuits have recognized this doctrine, but adopted their own tests. So we have tests sort of all over the map on this. The Third and Fourth Circuits recognize nominative fair use as an affirmative defense, which is considered only after the plaintiff has proved likelihood of confusion, sort of flipping this, both flipping the procedural posture and flipping the burden of proof. So from the Third and Fourth Circuit, it is on the defendant, and it only comes into play after there's been a discussion of likelihood of confusion. The Fifth Circuit considers two of the New Kids factors in conjunction with their standard likelihood of confusion analysis, sort of all jumbled together. And the First Circuit holds that likelihood of confusion is determined first, and only if found is do you look at nominative fair use, although they haven't addressed anything with respect to burdens of proof on this. And so you have a sort of all over the map. And the Sixth Circuit doesn't recognize the doctrine at all. So the Sixth Circuit says there's no such thing as nominative fair use. Obviously, this leads to a lot of potential forum shopping, depending on if you are a plaintiff or a defendant looking at if you're going to DJ or if you're going to file a case, knowing where it is that you want to file really can be very much dependent on how this plays out and which circuit you're in. So in the 7th, 8th, 10th, 11th, and District of Columbia and federal circuits haven't even expressly adopted the doctrine at all. They also don't have any guidance from circuit courts with respect to proper application. So it's sort of just a jumbled mess at this point. So in the International Information Systems Security Certification Consortium case, very short name, the consortium developed a certification program for the information security industry and owns the trademark or the certification mark CISSP. The defendants were certified through this consortium and initially used the mark in an authorized manner, basically indicating that they had been certified under this program. But eventually they they opened their own company providing information security training and began running ads to its teachers as Master CISSP or CISSP Master. And the consortium sued under the Lanham Act. Defendants claimed nominative fair use, and the district court granted summary judgment to the defendants, finding nominative fair use and no likelihood of confusion, following the Ninth Circuit's test. The Second Circuit reversed using this hybrid test, incorporating some variations of the Ninth Circuit test factors into the Second Circuit traditional 8-factor Polaroid test, and and ultimately rejected, I mean, they also outright rejected the Third Circuit's test or requirement that it is an affirmative defense. The defendants petitioned for cert on September 15th of this year and argued essentially that this new creation of a different test sort of exacerbates the circuit split issue, more problematic for forum shopping. And so unfortunately, I talked about this last year in another CLE, and we thought, okay, we would certainly hear what was going to happen in this next year. And as you can see from this slide, the answer is that the petition for cert was denied on January 9th. So what's the effect of this? There's no definitive federal standard for nominative fair use. So trademark owners should consider various approaches when sending cease and desist letters or bringing an action in court. And defendants, upon receipt of a cease and desist letter, should also consider their options very carefully. So if you are, as a plaintiff, you want to be cautious that if you don't want a defendant to file a DJ in a form that's beneficial to them, that you either pre-file a case in a form where you know there is jurisdiction before you even file the cease and desist letter, and choose not to, you can serve it or don't serve it, but at least be the first to file on that, or take a very, very soft approach in your trademark cease and desist letter such that it doesn't give rise to the ability of the defendant to file that DJ action. And of course, if you're a defendant and you get a cease and desist and you want to avoid, you want to have this where it is one of the areas where this comes up first and it isn't, you don't have the burden of proof on that, you would want to see if you can file an action, a DJ action in one of the forms that is more beneficial to you before a case is filed against you. So that is the International Information Security Systems case. The next case that I want to talk about is Roe Mag Fasteners v. Fossil. And this has to do with damages under the Lanham Act. So under 15 U.S.C. Section 1117 of the Lanham Act, it describes the type of remedies, financial remedies that are available to a plaintiff in a trademark infringement or unfair competition claim, and it indicates, in part, the plaintiff shall be entitled, subject to the principles of equity. So the first part's talking about injunction. We're not talking about that today, but so the plaintiff shall be entitled, subject to the principles of equity, to recover defendant's profits, any damages sustained by the plaintiff, and the costs of the action. No mention in this language, there's no mention of the term willfulness or a requirement of willfulness for any of these. However, this is another area we have a wide circuit split. I teach trademarks over at Drake, and I feel like all I spend my time doing is talking about the plethora of circuit splits in this area of law, so that you can constantly spend your time just trying to figure out where you might want to be as a plaintiff or a defendant. Here again, we are in a circuit split issue. So in this case, you have Roe Mag, the Roe Mag company. They own patents on magnetic fasteners used for fashion accessories such as handbags and other similar leather goods. They own a registered trademark for the word Roe Mag for the fasteners. The leather company Fossil originally contracted with Roe Mag to use their fasteners and their trademark Roe Mag, but Roe Mag discovered at some point that that Fossil was actually using counterfeit fasteners, acquiring cheaper fasteners but utilizing those with the Roe Mag name. So they brought suit for both patent infringement and under the Lanham Act for trademark infringement, counterfeiting, etc. So this case has a whole patent side to it, which in some ways is not, I'm not going to get into the details of it because this is a trademark discussion, but it is significant that there are patent causes of action in the case as well. So this case went to the jury, And the jury found that Fossil had acted with callous disregard with respect to use of the trademark. Yet they also found that they had not acted willfully. They awarded $6.7 million in profits from Fossil's profits. The district court, applying Second Circuit law, ruled that Roe Mag, however, was not entitled to profits, as there was no showing of willfulness. And so this case got appealed to the Federal Circuit. One of the reasons the patent is important. The appeal got filed at the Federal Circuit because there were patent claims that were also being appealed. The Federal Circuit has jurisdiction over those. So the trademark claims sort of went with the patent claims, and it was brought before the Federal Circuit. The Federal Circuit, however, in evaluating the trademark claims, used what they believed, how they understood the Second Circuit law to be with respect to this issue of trademark damages. And the Second Circuit had previously held back in 1992 that willfulness was required for disgorgement of profit. You know, there are three traditional reasons why courts have awarded profits, the defendant's profits, to a plaintiff in a trademark case: to avoid unjust enrichment to the defendant, to compensate the plaintiff for losses which are difficult to prove, and as a deterrence. And the Second Circuit, back in 1992, had held that all three of those rationales require a showing of willfulness. Second Circuit, so the Federal Circuit said, we're going to go with that. This requires a showing of willfulness. There's no showing of willfulness. We're going to take away the profits. And so the issue went up on appeal to the Supreme Court, and there were two issues that were raised. The first was whether under the one that's sort of relevant here is whether under Section 35 of the Lanham Act, willful infringement is a prerequisite for an award of an infringer's profits. And the second had to do with latches under the patent statute. And so the Supreme Court took cert. So we thought we might get an answer on this. But what they did, as an aside, I don't know if patents are being discussed today, but as an aside, the Supreme Court came down in, I believe, March of this year in this SCA hygiene products case and resolved the issue with respect to the patent side of this on latches, and basically eliminated latches as a defense in a patent case that's brought within 6 years under this 35 USC Section 286. So what the Supreme Court did here is that they took cert and then they vacated the case and remanded it for further consideration in light of the SCA hygiene products. There's no discussion at all on the trademark issues. And so the lack of clarity is continuing. Here again, what we're looking at is a circuit split. 2nd, 8th, 9th, 10th, and DC circuits all require a finding of willfulness for disgorgement of profit. The First Circuit requires willfulness when the parties are not in direct competition, and the remaining circuits do not require willfulness in any particular case, although they consider it certainly a factor to be evaluated under this principles of equity theory. This brings us to another case that came down this year. There is a petition for cert that was filed. So it's another case where we could have had this brought up actually to the Supreme Court. In this case, it's called Stone Creek v. Omnia Design. It is out of the 9th Circuit, and the facts in this case are that in 2003, a furniture manufacturer in Arizona contracted to buy Omnia's furniture branded with the Stone Creek mark. So Stone Creek, the Arizona company, is actually the owner of the trademark. They didn't actually have a registration back in 2003. They didn't apply for registration of that mark until 2011, but they had used that mark in commerce and had common law rights over their Stone Creek word, mark, and logo. In 2008, without getting any consent from Stone Creek, Omnia, the furniture manufacturer, decided to actually start selling Stone Creek branded furniture to another company, a company out of Illinois that did business mostly in the Midwest. They copied the mark without a doubt, and so from 2008 to 2013, Omnia sold leather furniture to this Midwest company with the Stone Creek mark. In 2013, Stone Creek started getting some questions from consumers asking, saying, I bought this furniture and I'm having a warranty issue. I'm calling you because your name is on it. And during that time frame, Stone Creek had developed a much greater internet presence, and so there was definitely some issues with respect to consumers calling and raising some objections. Not extensive, but certainly some. So Stone Creek contacted Omnia, who basically said, yeah, I can see that that might be a problem with the internet, but you guys are in different areas, it's not a big deal. So Stone Creek filed suit alleging trademark infringement and unfair competition, but they lost at the district court. The district court essentially looked to the Dawn Donut or T. Rectanus doctrines, which are some old doctrines coming from case law back many years ago that reference when parties or when marks are used in geographically remote areas that you are not entitled to any injunctive relief because there is no overlapping market there. And so number one, the district court said, well, there aren't any overlapping areas, you're in different marketplaces, you're in Arizona, they're in the Midwest, the closest possible thing is more than 100 miles away, so the T. Rose Rectanus doctrine prevents any injunctive relief for you. Additionally, the court also made an evaluation because under the T. Rectanus doctrine, the concept is that a junior user who adopts in good faith in a remote area is not, can't be enjoined as long as there is no overlap. And the court indicated in that case, in this situation, that despite the fact that obviously Omnia knew of Stone Creek and Stone Creek's ownership of the mark, Omnia did not act in bad faith because they were looking at it, this is a different area, it's perfectly fine in their mind, they didn't seek consent, but at any rate the district court said they acted in good faith. And so for that reason as well, there is no infringement. And then there was also discussion of willfulness and whether that is required for the disgorgement of profits. And again, the court said they didn't act in bad faith. This wasn't willful, therefore there would be no disgorgement of profits. The Ninth Circuit reversed, finding, number one, looking to that same good faith question. They said that it requires good faith. It didn't exist here because Omnia obviously knew about Stone Creek and failed to seek their permission. And so for that reason, they did not act in good faith. And two, the doctrine is no longer automatically applicable in today's day and age because of internet sales. So even though the district court took the position, it's furniture. Furniture is large. People don't purchase furniture over the internet. I'm not sure about anybody else's experience, but that's not mine. Everyone I know is ordering their furniture online. Room and Board, Crate and Barrel, everyone's buying it outside of Des Moines, so I don't think that that's actually true, but that is sort of just that was the district court's position, is that people don't buy furniture online. The Ninth Circuit held with the issue of the internet and far greater ability for overlapping markets and people to have that recognition, that is another reason that this should be reversed. So the Ninth Circuit reversed, and the disgorgement issue, however, did not come up on appeal So there was no discussion with respect to that. At any rate, Stone Creek, Omnia filed for a petition to for cert on November, I think it's actually the 13th, I have the 13th and the 15th here, but November 13th of this year. And their question that's presented in there is, how is good faith use established for purposes of the T. Rose Rectanus doctrine? So we'll see what the Supreme Court does, if they decide to take this up at all or not. So in the interim, we're still left in a quandary of trying to figure out what's willfulness, what's good faith. All of these things are still sort of up in the air and somewhat dependent on which circuit you are in. So the next case is other things that'll be more to watch for in next year. We have the Nance, I don't know how to pronounce this, Nance West case v. Mattel. So this case is actually a patent case with potential trademark implications. So under both the Patent Act and the Lanham Act, if a trademark or patent applicant disagrees with the PTO's refusal of the application for patent or trademark, or disagrees with a TTAB decision on a cancellation, opposition, or refusal of a trademark, or the PTAB refusal, there are two alternatives that you can take. You can either appeal to the Federal Circuit, and that sort of streamlined appeal with your record closed based on what was before the TTAB, or you have the option to seek de novo review in a federal district court. And historically, people have had the opportunity to do that, and there is a distinction, however. There's always been sort of a monetary issue associated with this. So if you, under both the Patent Act and the Trademark Act, there is language in the acts that require that if you take that alternative route and you decide to go to the district court instead of to appeal directly to the Federal Circuit, that all of the expenses of the proceedings shall be paid by the applicant. And so, the Lanham Act does it whether it's by the applicant, if it is relating to refusal of a registration that is an ex parte decision through the TTAB, or by the party bringing the case if it's in the opposition or cancellation proceeding. So it puts the burden of the expenses to be put on the person bringing that case in that alternative venue. So up until 2013, the U.S. PTO and courts had only ever really interpreted the term expenses under these acts to mean things as such things as agency costs, expert witnesses, court reporters, and the like, but nothing with respect to attorney fees. But in recent years, the PTO has challenged this. So back in 2015, the PTO challenged the interpretation on the trademark side of the equation in Shamus v. Focarino, which was in the Fourth Circuit. In Shamus, there was a TTAB action, sought review at the district court. At the end of the case, the PTO requested the court order Shamus to pay all of the U.S. PTO's legal fees in addition to other costs, and the district court awarded those fees. And that decision was upheld by the Fourth Circuit. Shamus filed a petition for cert, but the petition was denied. So more recently, the issue arose again in this Nance West case in the patent context. Like Shamus, Nance chose the de novo review, and the PTO at the end said, great, pay all our fees, pay our costs, pay for the attorney's fees. And the government, and basically essentially the government was saying, unlike private attorneys, that bill by the hour and collect fees from a client, it's the government. We are on salary, so our fees are more similar to expenses than they are to a traditional attorney's fees. So, but in that case, the district court held that the PTO was entitled to recover expert costs, not the attorney fees. So the court looked at Shamus, but rejected it. They said it's not, we don't have to, it's a different circuit, we don't have to follow it. And so they went down a different route. But and ultimately, the PTO appealed this to the Federal Circuit, arguing essentially the same things that they had in the Shamus case, that these are more like expenses than fees, and that basically the expenses provision ensures the economic burden of conducting district court appeal proceedings fall entirely on the applicants who elect those proceedings rather than on the public or the USPTO users whose fees fund the agency's operations. So of course the significant part of this is that this is regardless of whether you win or lose. So this isn't a traditional fee shifting type situation where there might be some fee shifting if you've lost. This is regardless. You can appeal the de novo review and still win and still have to pay all of the costs. So ultimately, the Federal Circuit this year came down and said, we disagree with the district court, we're going to follow Shamus, and turned around and essentially put into effect the same thing, that the PTO was entitled to fees as well as costs. However, it's not over, because in August, the Federal Circuit, acting without request of either party, decided to take the issue up en banc. And so the USPTO filed its opening brief on November 16th. We certainly won't have finality in this until 2018. And then we can see what happens after that. But we do know that this is still undecided, and certainly the fact, from my perspective, certainly the fact that the Federal Circuit decided to take this up en banc without being asked to by either party suggests that they might come down on this differently, which means then we would have a circuit split on very similar language that this might, in years to come, perhaps next year, perhaps the year after, end up with a Supreme Court decision. So briefly, I just have a few other things. These were all the substantive ones, and then I thought if we had time, it's 10:55, is it? So we don't really have time, so we could stop. We have time for a couple questions. Okay, questions?